And I'm going to start by talking just a little bit about a few questions I've had on assignment 3, and that will lead us very nicely into what we are going to talk about today. So a couple of people are getting confused with McKinney's Session Laws and NYCLS, or New York Consolidated Laws. So I'm coming back here to Sources of the Law. This is a good handout to keep in mind when you're getting confused about what's what, because a good part of the time this hopefully will answer it. So here we have McKinney's Session Laws. Remember what a session law is: the basic enacted by legislature organized chronologically, and remember, by the magic of the force and codification, they get put into subject arrangement, a code that's currently in force. And that's what CLS is. What I will do here is update this and indicate that it's NYCLS. Hopefully that will make it have more sense for you, make more sense to you rather. So New York CLS is the code. That's what's organized by subject, by title here in New York. So again, we've got the tax code and the domestic relations code. Some of you may be running into other codes like name of general business or agriculture, all sorts of different named codes. So CLS is one version. That's the version you find on Lexis, because Lexis publishes the print. And McKinney's is the version you find on Westlaw, because it's published by West. And McKinney's is what most attorneys refer to when they're referring to the New York Code, because that's just what they're used to using. So I hope that clears up some confusion. And one thing I wanted to point out, which will lead to today's discussion, is below our chart here, I have put in rather small print, but you have a handout, and you can link to this from the course webpage, some abbreviations. So by now, you're probably familiar with a lot of them because you've been reading them in cases for 2 or 3 years, but they are here for the ones you are less familiar with. So again, if you didn't know what CLS stood for, you could find it here to explain. Which leads us, these abbreviations that you are more familiar with, I'm guessing, to cases, because you've been reading cases now for 2 or 3 years again. And we are finally coming around to discussing that area of primary authority, against a source of the law. We've talked about the legislative branch. We're now moving to the judicial branch. And of course, as I've said, where you are probably more familiar. So just a quick review, so we're all on the same page from your legal writing. Looking at cases, of course, we have the different levels of court, and we will be talking about that at length in just a minute or two. And again, on the federal end, the lowest level starts at the district courts. Again, I'm sure you all remember this from legal writing. Then we have the courts of appeals, and there are different circuits of courts of appeals. We, of course, here in New York are in the Second Circuit. And then, of course, the U.S. Supreme Court that we read a lot about or hear a lot about in the news. Here in New York, of course, New York, and this is going to be a theme for the day, New York likes to make things complicated. I don't know why. So in New York, for whatever reason, the lowest court is called the Supreme Court. That confuses the daylights out of everybody. I'm sure there's a reason. If you know it, I'd love to hear it, but I don't. So the lowest court, the trial court, is the Supreme Court. And what we will note here is the abbreviations of the reporters where we see that trial level. So MISC stands for miscellaneous. Has anybody heard of that? Yeah, good. Okay, good. You do remember your legal writing well. And of course, NYS stands for New York Supplement. That's the unofficial source. From the Supreme Court, the next level up, the appellate level, is at least named commonsensically the appellate division. So we have the abbreviation AD3D for the most recent, and again, New York Sup NYS 3D. And then we go back to getting confusing again in New York. We get appealed up to the Court of Appeals, which is the highest court in New York, even though it sounds like it should be an appeals court. Again, I don't know the reasons for the naming. So the highest court in New York is the Court of Appeals, and the abbreviation is NY3D or NYS 3D. For other state structures, those of you thinking in going to Florida, Pennsylvania, or whatever other states you have in mind, the Blue Book is actually a really great place to look to get a sense of the structure of your state's courts, the abbreviations, what they're called, if they're a little bit more logical than New York or not. Another trick I will tell you is that for any state's highest level court, the official abbreviation tends to be the state abbreviation. So when I see an NY, I know that's the highest level in New York. If I see just CONN, it's not the postal abbreviation, but it's just the state abbreviation CON for Connecticut, I know it's the highest level in Connecticut. PA, just PA, is going to be the highest level for Pennsylvania. You get the idea. Again, you can find all this in the Blue Book. Okay, so that's a start in cases. Why do we care? Why do we bother with cases? Anybody remember from legal writing? I'm sure you do.
I mean, it's an accurate precedent.
Because we look to cases for precedent. Exactly. And that is because of or known as the doctrine of, anybody remember the Latin term? Stare. Oh, good. You're all good. Okay, so a seemingly simple concept of following precedent is why we need to do case research. Seemingly simple, but it can get a little complicated, so we're going to talk a little bit about those complications. So to understand what we're looking at and citing to, we're going to go back to first principles. So we need to know what is precedent, so what should we be citing to? And as I said, we'll go back to first principles, and that's what your walkthrough handout is about. And those very first principles start with, as you'll see on page 1, textbook some of you, I'm sure, had from Professor Newman, Legal Reasoning and Legal Writing. This is actually an older edition than you probably used. I like this older edition just because it has some language that I think really hones in to help us understand what we need to know for research purposes. So again, we're traveling back in time to your legal writing class. So turning to page 2. So we have this wonderful chart. Again, back to basics here. So we have primary authority, one part of the chart, secondary authority, and the other. We've already talked about the differences there. And of course, for mandatory primary authority, for that precedent that we need to look to in our legal system, it lists pretty much in order of authority. So, of course, we've got the Constitution, and then below the Constitution, statutes, then case law, then court rules and regulations. We'll be talking about those in following weeks, a couple of weeks from now. And then all of these, and this I find, and this is one of the reasons I like this handout, so we look to these that govern the court which your lawsuit would be decided. So how do you know if it's precedent for you? You think about, okay, if I am representing a client and my issue goes to a court, what is the court that would govern my issue? So we're going to look into this question. So as we see in our handout, it starts to tell us a little bit about the difference between primary authority and secondary authority. We've already discussed this. Make sure you keep this clear. Some of you in your assignments are referring to secondary authority as law, and I'm not quite sure that's what you have in mind, so I'm not too concerned, but when you see New York jurisprudence, don't refer to that as a case. That's not a case, it's a secondary source. But otherwise, I think, are we all clear on the difference between primary and secondary authority? Anybody have questions? Because now's the time to ask. The only time. Okay, so now let's look to the difference between mandatory authority and persuasive authority. Again, back to basics here so we understand what cases we need to research. So here on page 3 on the handout. So, of course, mandatory, and underlined the key passages here, mandatory authority is primary authority that has been acted by the government whose law controls the outcome of a particular dispute. So again, that same idea of which government, which entity, which court controls the outcome of your issue if it were to go to court. So as I mentioned, well, we'll get there in a second. Okay, so as we already know, the idea of authority, court is bound only by decisions from higher courts within the same jurisdiction. So now we have the concept of location, location, location. You know, they joke in real estate, that's what you worry about. Well, in legal research, in the question of authority, that's also one of the things we worry about. Location, 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 the same jurisdiction. But that definition of what's in the jurisdiction can get interesting. So, the easier question, a U.S. Court of Appeals decision binds only the federal district courts within its circuit. The Court of Appeals do not bind state courts or each other. So, and again, this is just a review of what you talked about in legal writing. So here's the map of the circuits for the federal courts, and you can see this on page 6 as well, just if you want to see it up close and personal. And again, we're in the Second Circuit, so a Second Circuit decision, in the Second Circuit, we're not going to be bound by a Third Circuit decision or a Ninth Circuit decision. Even if we're a federal district court, the lowest court in the Second Circuit, we're not going to be bound by a Ninth Circuit, even though it's from the Court of Appeals. Of course, we're all bound by the U.S. Supreme Court. So, basic review, right? Heads, yes, no, maybe. Alternate Thursdays in February. Hey, we're in March already, so we're past that. Okay, we're good. Okay, here's where it starts to get a little more interesting. State Supreme Court binds all lower courts in that state. Okay, that's pretty straightforward on issues of state law. Then there's the good old Erie Doctrine. And don't worry, I'm not going to go over that. You all went through Civ Pro. You probably understand it better than I do at this point because it's been many, many moves since I studied that. So, of course, under the Erie Doctrine, we do have to think about it because state appellate courts bind any federal court applying state law in a diversity jurisdiction case. Again, that's the basic Erie principle. Some states are divided into more than one appellate jurisdiction. In that case, the intermediate appellate court might bind only those trial courts in its jurisdiction or all trial courts of the state. And once again, part of the theme for today is New York makes things complicated. So here in New York, we do indeed have 4 appellate divisions. And you see the list here. We'll be looking at this a little bit more carefully when we get into the nitty-gritty of New York. Okay. So we have the basic idea of jurisdiction affecting authority. What exactly is the hierarchy of authority? So, of course, we all know mandatory authority always outranks persuasive authority. So even though there is a great case in another circuit, mandatory authority in our circuit is always going to outrank. So here's where it gets interesting, because I'm not sure if everybody really has thought this through, at least in legal writing, when you first got introduced to all this. So some mandatory authority outranks other mandatory authority. So a constitution prevails over an inconsistent statute. Not surprising, the Constitution's the highest law in the land. We've heard that phrase a lot of times. Either a constitution or a statute prevails over inconsistent case law, court rules, administrative regulations, agencies' decisions. So that's true unless a case finds a statute unconstitutional. So what this is saying is that statutes basically outrank inconsistent case law. So a lot of you in your statutes assignment say, well, you know, statutes are okay, but I really need to look at the case law because you didn't really say this, but the implication was there. I really need to, the cases are what are important, and maybe if I find a statute, that's good too. Statutes can outrank cases. Again, cases can ultimately declare a statute unconstitutional, but that's really the Constitution outranking the statute, which we already know from our hierarchy, the Constitution is the highest. Now you see that basically again in the other phrase I underlined, statutes trump the common law. So pretty much that's what I'm saying. Okay, so we see here, when thinking about statutes, and we've talked about this already, within the same jurisdiction, any new statute trumps any prior inconsistent statute, regulation, or decision. So this is why I keep on saying update, 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 because a more recent statute will update a prior statute. Okay, and now here's where it gets fun with regard to cases. Within the same jurisdiction, a decision from a higher court outranks a decision from a lower court. That's pretty straightforward. We knew that from legal writing. If the higher court has the power to reverse the decision of the lower court. Makes common sense. So one way I like to look at this, and when we get into the nitty-gritty complications in a moment, we'll ask this question. If you're a judge in a court, where will your decision be appealed to? And so when you're thinking about, okay, does this court have authority over another court? Think about if you're in the lower court, would my decision get appealed to that higher court? And as you already learned in legal writing, within the same jurisdiction, so within the same court, the higher court overrules one of its own prior cases, again, updating, and updating, we'll talk about that for cases next week, or if it decides a case in a way that's inconsistent with one of its own prior decision, the prior decision is no longer valid. Again, so within that particular court, a newer decision outranks an older decision if there's inconsistencies. All right, so that's kind of the review of first principles. Any questions about that? So when thinking about precedent and hierarchy, as I said, location, location, location. We need to think about jurisdiction, or I like to think of it, we need to orient ourselves in the time-space continuum. We need to think about where we are. So jurisdiction. So let's think about questions about jurisdiction. So on page 6, we already took a look, and we thought about jurisdiction with regard to federal courts. These questions, at least for our purposes, are more straightforward. But let's think about New York, because as I said, New York likes to make things complicated. So let's look at page 7, which is what we've got up on the screen. So basically, we have different appellate division departments. Remember, the middle level is the appellate division, the only one whose name makes sense. And you see those, basically, the different counties in New York, the different locations in New York are divided up into different departments. First department, Bronx and New York County. Anybody know New York County is what do we normally call New York County? Manhattan, exactly. Okay, so that's the first department. Second department, of course, here in Nassau, we're in the second department. Okay, anybody live in Brooklyn? Okay, so where's Brooklyn? It's Kings County. I don't know if everybody knew that. I didn't originally. And what about Staten Island? Richmond. Okay, so you guys, you went over this in legal writing? Nope. Okay. Yes, no, maybe. Okay. And then you see the third and fourth county, which if you're from Long Island the way I am, you just call upstate, and don't say that to people from upstate because they get somewhat offended. But anyway, so the third and fourth departments are areas north and west of here. Okay, looking at page 8. Any of you hear about judicial districts? Basically, judicial districts exist. They are really not that relevant for precedent and authority purposes. And so the only reason I have this handout and this slide, or this website up, is don't worry about judicial districts. You're worried about departments. Okay? And here's where it starts to get fun, turning to page 9. So here we see the level of hierarchy. And let's focus on civil court structure. As you can see, there are different trial courts. So there's, of course, the Supreme Court, but there are other courts, which are sometimes referred to as lower trial courts. And then they get appealed up to either something called the appellate terms or the appellate division. And my sources of the law chart, I just referred to the appellate division. I didn't refer to appellate terms. And this is where New York gets immensely complicated. I showed you a week or so ago the New York Legal Research book, and there's a great explanation in that, but it's incredibly complicated. And one of the lines it says is that New York is one of the most complicated court structures in the country. So if this is confusing, you're in good company. So what I'm going to try to do is I'm not going to try to explain it all because we would take the whole 3 hours and then some. And it really wouldn't do you a whole lot of good unless you run into issues. So what I'm going to try to do is boil it down to what you should look out for. And then when you encounter it, then you know you have to investigate it further. And essentially what you should look out for are the differences between appellate terms and appellate division. And when you're reading a case, it will tell you where it's from. So that's kind of the bottom line. I'll go into a little more detail to hopefully make it more sense, have it make more sense for you. But as I said, that's pretty much the bottom line. So we see that on, believe it or not, page 9 is the simple chart. So we see we've got the courts of original instance, and there's the Supreme Court, and then there's all these other courts, and they either go to appellate term, county courts, and then the appellate division, and of course the Court of Appeals is on top. And the way I'm hoping to help it make more sense is from a secondary source, page 10, Carmody-Waite. For those of you who are planning on staying in New York and planning on being a litigator in New York, this is going to be a wonderful source to know about. We ran into it a little bit when we talked about secondary sources, but it's really geared toward litigation in New York. And so it talks about the section I've copied here, binding effect of trial court of intermediate appellate court decisions of another department. So the question is, what happens in New York? We know we have 4 departments. We know we're in the 2nd department. What happens if there's an appellate, we're in a trial court level, say we make it simple, we're in the Supreme Court level. What happens if there's a decision from the 3rd department or the 4th department or the 1st department? Is that binding on us, or is it merely persuasive? And here we have most of the answer. Trial court must follow appellate division precedent in its own department. Well, that kind of makes sense. That should be pretty easy, right? However, in the absence of a relevant decision in its own department, a trial court is bound to follow applicable decisions in another department of the appellate division until its own appellate division decides. So, if there's not a decision on your issue, you, as a trial court, are bound to follow other departments. So here in the 2nd department, if we've got an issue and the 2nd department appellate division hasn't addressed it, but we find a case in the 3rd department, we have to follow it. Make sense? Did you go over this in legal writing? No? Okay, good. So continuing back on page 10, doctrine of stare decisis requires trial courts in one department to follow precedents set by the appellate division of another department until the Court of Appeals, the highest court, or the appellate division in its own department pronounces a contrary rule. So I've pretty much just said the same thing in a different way. Or read the same thing that says the same thing in a different way. Okay, so here's where the complication exists that you got to keep aware of. I don't think you'll run into it very often, but you need to be aware of if you do. And in contrast, decisions of the appellate term, so not the appellate division, the appellate term. And when you read the court, if it's a New York case, you need to locate yourself in the time-space continuum, location, location, location. You need to see, is this appellate term or appellate division? If it's appellate division, I just read you the rules. If it's appellate term, the rules are different. And they are, in contrast, decision of the appellate term of one judicial department, not binding, the decisions are not binding in the lower courts of other departments. Okay, so here in the, if we're in a trial court in the second department and we run into an appellate term from the third department, it's not binding. It could be persuasive. The judge may think, well, you know, they kind of know what they're doing in the appellate term, even if they're third department. I'm going to be persuaded by their reasoning, but it's not mandatory authority. So such determinations would have less binding authority on the Supreme Court. Again, that's the lowest court, which is not subject to the appellate jurisdiction of the appellate term. So if you turn to page 11, remember I said the chart, this chart is the easy one. Page 11 is where you get all the details, and I'm not going to go into that level of detail, and I wouldn't worry about it. I'm certainly not going to ask you to understand this for purposes of our course, but be aware if you are practicing in New York that this complication exists. And again, most of the time, you'll have a case, trial court, Supreme Court, it'll be appealed up to the appellate division, and then if appealed again from the appellate division to the Court of Appeals. So for research purposes, is this mandatory authority? Do I cite this as mandatory or persuasive? This is where you start to think about this. And if you're talking about appellate terms, if you're talking about conflicts between circuits, or if you're talking about where there's nothing in your department, but there is something in another department, that's where you need to start to think about this. And most of the time, what I read you on page 10 will serve you. But there are going to be instances, if a decision on your issue is from an appellate term, then you got to start thinking about the complications on page 11. Okay, questions? Are you feeling like this is making sense, or are you totally confused? Okay, so who's feeling like this is making sense? And who's totally confused? And don't be shy, because I sometimes can get totally confused by this, and I teach it. Okay, if you have questions, let me know. If I can answer them, I will. If not, I will point you to a place that I think can answer them. And one of those places would be Professor Newman. Okay, so we've established in terms of authority and what we are researching that jurisdiction, location, location, location is really important. So there's authority. So what is authority? What is persuasive? Another thing we need to think about with regard to authority is publication. And again, I'm thinking you talked about this in legal writing. Published cases versus unpublished cases. Ring a bell? Seeing some heads yes, some heads no. Okay. So generally when we refer to case law, we're referring to published decisions. So what do I mean by published? I mean published what we get in basically those reporters that we look to on the sources handout. So in New York, the miscellaneous, New York SUP, Appellate Division, New York Reporter, and in the federal instance, the FSUP, F2nd, 3rd, and of course the U.S. Supreme Court. So that tends to be what we refer to when we talk about published. So let's take a look again at New York, because once again, New York makes things complicated. And for that, I printed out for you this handout from the New York Law Reporting Bureau website. And let's see, is that what I got? Let's go here. So it's on the screen here, but you'll be able to read it. And again, I highlighted for you the important parts. So here in New York, we have a state reporter who's authorized by statute to basically pick out the cases that they determine should be published. In other words, put in those print reporters, miscellaneous, Appellate Division, New York reports. And for the trial court level, you can see, get the approval from the Court of Appeals and considers the case as most worthy of being reported because of its usefulness. Now, what's interesting and what most people don't realize, especially most people who haven't been to law school, is that most cases don't get published. So if you see further down, I've highlighted According to the New York Reporter, we publish approximately 500 appellate term and trial court opinions in full text in miscellaneous reports. This constitutes less than 7% of the opinions submitted. So think about that. In the trial court, less than 7% of the opinions that are submitted actually wind up being case law. Turning the page. What do they publish? Well, there's a statute, judiciary statute we saw on page 1, and then there are regulations that apply that, and we'll be talking about regulations and how all that works after spring break. But the statutory criteria that the regulations apply are those arrows below, and I forgot to put arrows on the last 3 on the bottom of this second and top of the third page, but you can see precedential significance, novelty, public importance. So basically, the state reporter, with the approval of the judges, determines which 7% of the thousands of cases that get decided every year actually get published. And we see, interestingly, I think I gave you somewhat old, but it's still applicable on the federal side, this handout Court Rights Decisions That Elude Long View article from the New York Times. And it talks about unpublished decisions, as 88% of decisions issued by federal appeals courts are unpublished. So I talked about the 7% in New York that got published. What happened to the others? Those are considered unpublished, and different things happened in different jurisdictions. So here in the federal world, 88% are not published from the federal courts of appeals. So this means that no precedent is set. So that's why you care about published and unpublished, because depending on your jurisdiction, it may or may not be precedent. So we now know from this article and other resources that in the federal world, an unpublished decision is not precedent. We still may cite to it, because if you look further down, this article talks about that in this paragraph that I highlighted, because there are still unpublished decisions. We run across them in Lexis, and we run across them all over the place. In Lexis and Westlaw, we run across them in legal newspapers like the New York Law Journal, and I'll be showing you how to recognize them in just a moment. So with regard to unpublished, it doesn't mean we can't see them. It just means they're not officially published in the official reporters. So all the ones of the abbreviations we just looked at. So that's the federal world. Similarly, in New York, we have unpublished decisions. Yeah, question.
Does that mean that the unpublished decision is persuasive authority, not mandatory authority, because it doesn't set precedent?
Yes. I mean, it could be persuasive. You could cite it. So the rule, it says here in that paragraph, you can now cite to unpublished decisions in the federal appeals court. Back before 2007, you couldn't. You could cite to it, but you can say, hey, appeals judge, here's this decision that we love in the Second Circuit, but it's unpublished, so you can't say, hey, this is the law. You can just say, hey, we think this is a great decision because, and hope that the judge is persuaded. So the short answer to your question is yes. I just gave you the long answer. Good question. Any others? Bless you. Yeah. Depends on the state. And of course, in New York, we have to make it difficult. Give me a moment and I will give you a fuller answer to that. But, okay, so let's take a look at published versus unpublished. So we already know what we're looking for in published. It's in one of those reporters where we've looked at the abbreviations. For unpublished, and I'll have to ask you to keep your finger, oh good. So we find these unpublished decisions in a whole bunch of different places, like I said, online primarily. So when you're doing a search on keyword search on Westlaw, on Lexis, you will pull up these cases along with all the others, and they really won't be distinguished. There is a way to filter out reported, unreported. That's another way of saying published, unpublished, by the way. I'll show you when we do a keyword search on Lexis, on Westlaw, where you can do that. Don't know if you can do that on Lexis in the filters. We'll have to take a look. But just so you know, you want to think about it every time you look at a case. Can this be precedent or not? And of course, we already talked about jurisdiction and hierarchy, but you also need to now look at published versus unpublished. And the way I know that this case is not published, a couple of ways. Basically, it's an older case. It's not 2019 or very, very late 2018. And Westlaw tells me here it's not published in FSUP. And if I am reading a citation in a brief, in a memo, in whatever, and I see a Westlaw or a Lexis site, and I know it's Westlaw or Lexis because it's abbreviated WL for Westlaw or LEX for Lexis, and all I see is that citation and nothing else, that tells me it's unpublished. So very important because there are two components here. The date, it's kind of old, and all you see is Westlaw or Lexis site. So let's take a look at, now Lexis makes it, I think, a little easier. Again, those same two components apply. So we see just a Lexis site. Now it's a little confusing because it says New York MISC Lexis. And MISC is an official. So what it's telling you is that it's the lowest court. But there's no just miscellaneous site. It's Lexis. So that's the key. And again, it's kind of old, 2000. But Lexis makes it easier in another sense, and it says, notice, not approved by reporter of decisions for reporting in state reports. So just look for that on Lexis. Unfortunately, Westlaw doesn't do that, but they don't confuse us with adding that MISC in there. Okay, are we good so far on what an unreported case looks like on Lexis and Westlaw? So now a very recent case. Very recent cases will be a little bit confusing. So here's a case from February 2019. This will be a reported case, and here on Westlaw, I know that because it's telling me basically up here, eventually we're going to have an NYS 3D site, but we don't yet, so we're just putting dashes there because we don't know what the actual volume and page number is going to be. I still see the same Westlaw site, 2019 WL, but now I know, okay, 2019, that's pretty recent. And I also see that NYS, that official abbreviation, it's not really official, but that reporter abbreviation, I see that. So that's telling me, okay, this is more likely to be not yet reported because it's too new. And again on Lexis, ooh, my Lexis recent site, let's see if, all right, I'm going to have to type in, bear with me. Computer lost my Lexis site, so just give me a moment and I'll type in. So this actually might be instructive. So I'm typing in 2019 NYAPP DIV Lexis. And again, because I see Lexis in the site, I know that this is either not reported or very recent. And pretty much I know it's very recent because I just typed in 2019. 306, there we go. And February 21, 2019. So, and again, Lexis gives us that app div, but because the Lexis is in the site, I know that it's a Lexis site, obviously. So I know now I need to look at the date, 2019, so that tells me it's very recent. And also, again, Lexis gives me the notice. This Lexis pagination of this document is subject to changes pending the release of the final published version. So again, watch for that notice on Lexis. When you see Lexis in the citation, look for the notice. When you see Westlaw in a citation, look for the date. And look up top to see if there's any reporter abbreviation. Does that make sense? So we now know we have to look both jurisdiction and hierarchy of court, as well as published or reported versus non-reported. So we already talked about in the federal world, it's okay to cite to these unreported cases, but they are not precedent. For states, you need to check the jurisdiction. And the best way to look, I found a note from a fellow law review student in a different law review. This article there's a link to it in the course website under the cases module. And this gives us a nice chart to let us know what the citation rules are for different circumstances. So here are states that prospectively publish all dispositions. So in New York, we actually publish everything. And Joshua very perceptively asked, well, can we cite to them? And the answer is yes, you can cite to them in New York. Are they precedent? Yeah, that depends. There's a case from 1990 that I've seen cited to in a bunch of different places saying there's no rule in New York that says you can't cite to it. So that means you can cite to it. But it also says, and this is in a different department, and this is a trial, this is a Supreme Court in the first department, I think, case from 1990, so it's not binding on us here in the second department. And it says that while they will give it due respect of unreported case, they don't feel bound by it. So it's the New York, it depends from this 1990 case in a department that's not binding on us. So that's why I say New York likes to make it complicated. So that's as best as I can answer your question. Okay, any other questions? They've all been excellent ones, as they always are. Let's just figure that page all together. Okay. So back here in New York, as I mentioned a couple of minutes ago, so we have the official reports. So the reporter figures out which 7% it's going to publish. And then there's everything else that they make available these days online, and they call that the New York Slip Opinion Service. And just so you know, so hopefully it makes a little bit more sense, back in the days before everything was online, the first place you would find a case published, so would be in this paper form called a slip opinion. And it kind of makes sense seeing it, right? It's kind of a slip or a piece of paper. So I don't know exactly the derivation of the term, but that's how they used to get published all over the place. And a lot of websites still maintain that terminology. So if you see slip opinion, that means that that is an yet to be published, possibly never to be published case. And so that's what the New York Slip Opinion Service does, is it gives us access to the decisions that will not be reported. Okay, so where are we going to find published cases? And then we'll talk about where we already talked about where we found some unpublished cases. Did I miss? Well, let's talk about where we find published cases first, then I'll talk about where we find unpublished, although we covered that mostly already. So published cases. We already talked about the published reporters. FedSup, F3D, Supreme Court in New York, the two different places. And you all hopefully remember from first year, there's the official place published by the state, and then there's the unofficial, like New York SUP. And that's all in the Blue Book. What you also might encounter, which you may or may not have talked about in your legal writing course, back to our walkthrough handout. Go to page 12. Something called nominative reporters back in the old days, and I'm talking really old days, like 1800s. Before this whole system came about, there were people, men really, who sat in court and took notes, and then they would report the decisions. And they would, of course, give those reports their own name, so they could sell them and make money. And so you see, for instance, on page 12, the name of those men who did that in the U.S. Supreme Court. And they were Dallas, Cranch, Wheaton, etc. Occasionally you will see citations with a name in it. That's what that means. It's just an old case, and it's called a nominative, which means name. They usually get translated over into the current system. So in the U.S. Supreme Court, they usually get translated over to the U.S. reports. But if you're reading a really old case, you might still see the old-fashioned name. So really what you should remember out of this whole explanation is if I see a name, it's just a really old case from somewhere. And you see the names in New York, and again, once again in New York, we have to make things difficult. And there's all sorts of names and all sorts of overlapping time periods. I certainly don't have any of these memorized, nor do I ever intend to, so I don't suggest you bother either. Again, just know, oh, if I see a name and it's a New York case, it's one of these old named cases. And if you know that, you're pretty much good. Questions about that? And last but not least, in terms of reported cases, the regional reporters, hopefully you remember from first year, basically for state reported cases. The unofficial reporter, our friends West, divided up the whole country. This is actually the back page of your sources handout. If you look to that, I'll scroll down here on the website. So basically, these are just the different regions where you will find cases, and don't assume those regions make sense, because for reasons I never understood, New York is considered in the northeastern. But of course, then there's Atlantic, which is further north, and then there's northeastern. Don't ask me how they came up with these names and how they applied to states. Just make sure you know where the state of interest is in when you are looking at these reporters. Questions about regional reporters or any other reporters? Okay, so that's official. So where else do we find reported cases? And again, I'm not sure if you would have covered this in your, see, that's the one, no, that's not the one. Let's go in your legal writing class. So there is a reporter called FRD, which stands for Federal Rules Decisions. So what happened is there is so much litigation with regard to the Federal Rules of Civil Procedure that our buddies who published the Federal Reporters West decided there's just too many to put in the Federal Supplement. So they took out all the, oh well, not all, they took out a lot of the cases with regard to the Federal Rules of Civil Procedure and put them in its very own reporter called the Federal Rules Decision, or FRD. So that's what that citation looks like. So if you see FRD, you know it has to do with the Federal Rules of Civil Procedure. Similarly, there is another reporter, the bankruptcy reporter. So bankruptcy, because it's just its own special area, it's got its own special case reporter. So if you see bank or BANKR, not surprisingly, that's bankruptcy. And there's an example there with 455 BR 590. Then you'll run into what are other topical reporters. So bankruptcy is obviously on a topic, right? Federal rules is its topic. So there are a lot of our secondary source publishers put out secondary sources in which they will find decisions, sometimes unreported, sometimes reported, that are relevant in their area. For instance, securities law. We have an example here of patent law. So there are specialized reporters that are published by secondary source publishers. So here's the U.S. Patent Quarterly that was published by BNA. Remember, BNA got bought out by Bloomberg. I actually don't know what's going to happen to this reporter now that Bloomberg owns BNA. I'll have to ask our Bloomberg rep about that. So you will see cases with different abbreviations that are specialized to these secondary sources. So you might see a reference to a securities law reporter that's put out again by one of the secondary source publishers, probably CCH. So you'll see a lot of references to CCH that's now owned by Wolters Kluwer. So again, you'll see a lot of these specialized reporters and citations. Sometimes they will have they'll appear in more than one places, so they'll have parallel citations, so they'll appear in the specialized place as well as a regular reporter, like this one also appears in the Supreme Court reports, but not always. Okay, so unreported cases, we already talked about. Most of the time we'll run across them in Lexis and Westlaw, but there are a couple of other places that we will find them. One of those places, and I hate West for this because basically they just make things way more complicated than we need them to be. There's a print reporter called Federal Appendix, abbreviated FEDAPPX, that basically has the unreported cases that appear in Westlaw. West decided it wanted to make money and see if they could sell it in print, which is why I dislike them so much, because it's really just to make money. So if you see a Federal Appendix citation, that is an unreported case. That is an unpublished, unreported case, even though it's in something called the Federal Appendix. Another place you'll find them, which I already alluded to, some legal newspapers, state papers. So here's a case. Again, we know it's unreported. It's old, 1996. It's got a Lexis site. But it's in the, now this doesn't have a note, probably because it's so old, but it's in the New York Law Journal. So you'll see here in New York, you will run across cases, a lot of cases in the New York Law Journal. In fact, when we looked at the New York Law Journal, when we were looking at secondary sources, when some of you did the workshop, you came up with cases. Since we hadn't talked about this yet, you had no reason to know that actually in the New York Law Journal, you were actually finding unreported cases. Now, some of the cases in the New York Law Journal do wind up becoming reported, just like the cases in Lexis or Westlaw wind up becoming reported, but a lot of them don't. So a lot of attorneys will be looking at the New York Law Journal cases. Again, it's not reported, so it may not be precedential, but it may be persuasive, because if a judge had made a decision this way, you've got a good argument to a different judge to make the decision the same way. Okay, any questions about where to find published cases, where to find, or reported cases, where to find unpublished or unreported cases, how to tell the difference? That's probably the key thing. Okay, so before we break, let's take a look at a case. So here's a reported case, just regular old 333 NW2D. We know NW is one of the regions, Northwestern. So again, as I mentioned, you want to make sure, you want to check out where you are in the time-space continuum. So we know this is reported. We know that this is in Northwestern. So for us, at least in New York, it's in a different state, Court of Appeals of Michigan. So it's probably a mid-level court in Michigan. I'd have to check the Blue Book to see the Michigan hierarchy. So I know at best this would be persuasive if I were interested in citing to this case. Now let's look at the different parts of the case. So of course we have the name and the court, and the date. We've talked about why the court and date are so important for citing and precedential and hierarchy purposes. Then here on Westlaw we have something called the synopsis. And this particular case I love to use an example because it's a little bit silly, because they decided to make it in rhyme. So wayward Chevy struck a tree whose owner sued defendants 3, and I'm not going to read the whole thing. But so the synopsis is just the summary, the West summary of the case. And then we have the head notes, and when we get back from break, we're going to be talking an awful lot about how to use these head notes to help us find cases. Then we have the attorneys, and then of course we have the opinion, the judge who wrote the opinion, and then the opinion itself, which again, just for reasons of trying to have a little bit of fun, also written as a rhyme. So those are the different parts of the case. Any questions? Okay, strategies for finding cases. there is absolutely nothing wrong with starting with Google. Once again, I wouldn't stop there. And I'm not sure if you all have encountered this or not, but our friend Google Scholar, where we took a look at articles, also provides us free access to case law. Now, the way I got to New Jersey courts here is I went to this Select Courts option. I'm just going to jump over here. So I selected for New Jersey in that Select Courts option, and I typed in drunk bicycle. Some of you may remember this hypothetical from Dean Selby from your legal writing class a year or two ago. This is one of her favorite examples, and we took a look at Google Scholar, and she determined that the State v. Johnson case was basically the controlling case in New Jersey for issues having to do with being drunk on a bicycle. But what was particularly interesting to me about this example is that even Google, as great as we think Google is, if you change one word from drunk to drinking. Now, right, the concept is pretty much the same, having alcohol on a bicycle and what is the law in New Jersey with regard to that concept. You no longer see the leading case, at least not on the first page, and I'm pretty sure not on the second page, and maybe in there somewhere. I haven't gone any deeper than that, and face it, most of us don't go much deeper than the first page. Forget about the second page. So the point being is that as great as Google is, once again, Google, and true for Lexis, Westlaw, Bloomberg, etc., keyword searching isn't the end-all and the be-all. If you don't get the right words, even though the words drunk and drinking is pretty much the same concept, right? Just different tense of the word. So you need different tools for finding cases. Now, again, it's not to say don't use Google Scholar or regular Google to see what you can find and learn, but if you don't find anything, do not assume there's nothing there. It may be your word choice. Okay, so what are some strategies for finding cases in addition to keyword searching? What I am going to spend most of our time talking about is a strategy that we librarians like to call the one good case strategy. So assuming you find that one good case, how can you use that good case to find other good cases? Because again, remember, maybe that good case isn't in our jurisdiction, maybe it's not reported, maybe there's a newer case that's going to supersede or overrule or do something to that one good case that we find. But of course, to use the one good case method, we have to find that one good case. So what are some of the methods we've already talked about? I already mentioned Google and keyword searching. What else is there? What's your best friend for research in statutes? Well, you just had a break. Your BFF for statutes? Where are you going to look in a code? What kind of code? Annotated code. And what feature in the annotated code? You're all looking at me smiling. Is this like a conspiracy? Should I start to get paranoid? Headnotes are in cases, but notes of decisions. There you go. Okay, so if you have a code section, a statute, go in the annotated code and look in the notes of decisions. Okay, where else? What did we start talking about in the very beginning of the semester? What kind of resource? Thank you, secondary sources. So again, secondary sources lead us to primary sources. Maybe statute sections, but also case law. Mentioned keyword searching already, both Google as well as Lexis and Westlaw. So those are all different ways where we can find our one good case. So once we find that one good case, and actually here's an example on Google Scholar again, the case law search. And some of you may remember in our secondary sources, we ran across this case, Aetna Health v. Davila. So we ran across this in secondary sources. If I did a Google search here, Liability Health Maintenance Organization, again, another way to get that good case. So we are going to take a look at this Aetna case because we have seen it mentioned a bunch of different times. It's a U.S. Supreme Court case, so it is likely to be important. And what we're going to focus on, as I mentioned before, are the headnotes. And essentially, these headnotes are numbered, as you can see, and they are essentially summaries done by the editors at West or Lexis. We'll look at Lexis headnotes in just a little while. They're summaries done by editors, so they are not the decision. No way, shape, or form should you ever cite to these. These are research aids for you only, but they are basically summaries of the different points of law discussed in the case. So whatever case you're looking at, if you see the headnotes, they're just the points of law discussed in that case. So it's a nice summary, so it's a quick way to say, okay, what's this case about? Is it interesting and relevant to me? But another use for headnotes are basically what we see here on the right. And on West, it's called the key number system. So you see this nice little picture of the key. And essentially, this is something you are actually already, I'm guessing, familiar with. It's a tagging system. So you've seen hashtags. What are some of the social media platforms that use hashtags these days? Twitter, okay. I know I see it when I go into Instagram. I'm not so sure about Facebook anymore, but so you're familiar with hashtags? Okay, good. So this is just a hashtag system. The only difference, and it's a big difference, but the difference being it's a tagging system, except you don't get to choose the tags, at least the way you get to on Instagram. The folks who, the database chooses the tags. And that's essentially all it is. So I think of it, I'm a big fan, and I use this example back maybe, I don't know if any of you remember if I was in your class in first year. So in the tagging system, if I want to check on Twitter and see, okay, what's going on with the Game of Thrones. Anybody Game of Thrones fan? Okay, good. I get some liveliness here. So, of course, it's a month away, right? So I've got to catch up and, catch up on all the characters. And remember, it's been, what, 18 months or something crazy like that? So I'm going to do the hashtag and Twitter or wherever else I'm going to go, and I'm going to see Game of Thrones. Now, I think the dragons are just the coolest. So within the whole Game of Thrones, I'm going to check out the dragons. And, of course, sort of spoiler alert, but I'm going to try not to be too bad about it. Of course, there's the blue fire. Those of you who are fans know what I'm talking about, and those who aren't, check it out. So there's the show, the Game of Thrones, so I might do hashtag Game of Thrones or GOT, and then I might do hashtag dragons or hashtag blue fire, and just do the whole string the way you see. So this is the same thing, only it has to do with law, not the Game of Thrones. But what you see is a hierarchy here. So you see that the broad subject, so in our case, or my example, Game of Thrones, and then you see the subtopics within the main subject, so dragons or blue fire or whatever else you're interested in with regard to that. So let's take a look at how that works in this system. And again, it's just a hierarchical system where the West, in this case, chooses the hashtags rather than you getting to put in your own words. So here is headnote number 8, and so point of law having to do with insurance, and actually it also has to do with these other subjects too, but let's focus on the insurance so we can explore how these headnotes work. So the overall topic is insurance, and then it's just broken down into subtopics. So like my example, Game of Thrones, broken down into dragons, broken down into blue fire. We've got the subtopic, what law governs, and it keeps on breaking down. So we see ultimately there's particular laws, there's employee benefits, and there's even one here, healthcare benefits. So if I'm scanning this case, I might see that. I might say, all right, I know I'm interested in all of that. Preemption, what law governs, preemption, employee benefits, healthcare benefits. So I might think, okay, this particular hashtag might be of interest to me. But the thing is, you need to keep in mind, again, the hierarchy, and it's a little bit different than the hashtags in that there are two pieces of information you always want. You always want the topic, which is the top level, and then you want one of the sub-levels, whatever that is. So let's run through that with one more example in the hopes of making it make sense. So here's head note number 9. It has to do with health and it has to do with states. So we're, of course, for our example, interested more in health. And then within the health topic, a subtopic of malpractice. Okay, we know that, but that's still pretty general for us. And then there's preemption. Okay, so that sounds pretty good too. So we have a couple of different tags that are of interest. So as I mentioned, the main difference, yeah, question.
So is that like if you clicked Head Note 9, this section following it deals with all of those things? Or is that like this Head Note 9 and what follows has to deal with health states, and here's some other things that you would be interested in? Like, will I find all of those things in this case? Or is that suggested to me?
Okay, so Head Note 9 is a point of law within the decision. So if I click on, and I'm going to answer your question, but I think this might help make it sense. If I click on 9, it's going to bring me to number 9 within the decision where it talks about this particular point of law. So the 2 points of law that are covered in this portion of the decision is health, the overall topic of health, and the overall topic of states. What you see here on the right is, okay, so health. What specific areas, health is obviously a hugely broad topic, right? So is states. What specific topic about health does this point of the decision talk about? So the particular aspect of health that this point of the decision talks about has to do with malpractice. Well, all right, malpractice is still pretty broad, so in general it doesn't really help us much, but within in general, preemption. So this particular Head Note 9 talks about preemption in the context of health. In number 8, when we were looking, it also talks about states and whatever we have here, particular cases, so preemption having to do with states, but that's not pertinent for our clients, so we're not going to worry about that. We're interested in preemption and health, right? Okay, so we're also looking at Head Note number 8, insurance. The same analysis applies. So there's the overall topic of insurance, really broad, right? There's auto insurance, there's fire insurance, there's a lot of different types of insurance. What law governs? So what law, if you're looking at a question about insurance law, what law governs? Oh, preemption. Preemption having to do with insurance. Okay, so we know that's kind of relevant, still pretty broad. Then it kind of breaks it down, particular laws or activities. Employee benefits is a particular activity, and then within employee benefits, because there are different types of employee benefits, there's healthcare benefits. So healthcare benefits having to do with preemption, having to do with insurance law. Does that answer your question? Okay. Everybody following? Any other questions? Okay, so again, these are hashtags or topics that are decided on by West. To give you a sense of what I mean by that, here is the West key number system. And the way I got here, if anybody is interested, is, okay, by Westlaw. Let's go back to the home page. I just clicked on key numbers. So it's right here on the home page, and here's the West key number system. So just to give you a sense of what these really broad topics that have to be broken down 4, 5, 6 times like we just saw. So just abandoned property and just all these different topics. There are over 400 of them. See them alphabetically. So if we wanted to see what the hierarchy of a topic looked like, we were just looking at health. So let's take a look at health. And these are just numbers assigned to the topics. So here's the breakdown of the health topic. So regulation and public health and government assistance and relation between patient and healthcare provider and malpractice. So this obviously something we're more interested in, and then we could maybe guess persons liable because we're asking if our HMO is liable. Now I'm showing you that this is essentially a table of contents. You know how much I love tables of contents. I don't recommend you going this way to try to find headnotes. You can if you want, certainly. It actually doesn't cost anything on Westlaw, but these days it's not the best way to do it. I am showing you this to hopefully help you understand how this topic system works. So again, we see the hierarchy within health, malpractice, person's liable, and then we see, oh, check this out, health maintenance organizations. So this is how the hierarchy works. And actually what we saw, the in general, I hate that they use in general, but they do, so you just have to deal with it. This is actually the key number we saw in our case. Which is one reason why I don't like to use a table of contents, because in general doesn't mean anything and they use it all the time. At least it doesn't mean a whole lot to me. Okay, but what can we use this key number? So let's move on to what it is really useful for. And it's really useful for finding other, why you would use a tagging system, why I would click on Blue Fire Game of Thrones, because I want to read more about it. So why would I use these key numbers? I would click on it because I want to read more about that particular, or more cases about that particular topic. So looking at any of our, again, relevant key number headnotes, I would take a look and I would decide, so hey, I know I'm interested in insurance and preemption, and within these, I mean, I could click on each and every one of them, but honestly, I would go for the one that just sounds the most relevant to me. And yes, preemption sounds relevant, but this is healthcare benefits within preemption. So I'm going to go with the one that sounds the most relevant. If I were to go to, and I'll click on that in a moment, but just to hopefully help you understand, Headnote 9, we just looked at health. So health is way too broad. Malpractice in health is way too broad. Again, I hate in general. But preemption. So I might click on that one. So you can click on any of these in the hierarchy. So back up here, let's click on healthcare benefits within insurance law. And Westlaw makes it pretty easy. You just click on it. The only thing you need to remember, the trick, if you will, is that because we started in a Supreme Court case, Westlaw assumes you want the jurisdiction Supreme Court, which obviously we want to expand our jurisdiction, right? So we just change the jurisdiction and we change it to whatever we want. So I'm going to say New York and related federal, but obviously whatever jurisdiction, you could keep it all jurisdictions if you want. And when I click on apply, I now see where this tag, where this key number, same concept, has been applied to cases in New York and federal. And what I get are the headnotes for all of those cases. And it looks like there are 62 of them. And don't worry so much about numbers. I'm just pointing out to you what we see on the screen. But what the number does tell me is maybe I want to narrow this a little bit more. I could look, 62 really isn't too much to scroll through. But as I like to say on the late night commercials, but wait, there's more. There's our favorite search within results. So I've now looked at cases where the tagging system has been applied for healthcare benefits having to do with preemption and insurance law. Maybe I want to look at, see where they talk about denial of coverage. And when I say where they talk about, it's the headnotes. You're not searching the full text of the case. You're just searching the headnotes because we just did a headnote search. Remember, we clicked on the key number, the headnote key number. So I can put in a search term like we can with search within results. So I'm actually going to keep it pretty straightforward and just type in DEN exclamation. So I get denied, denial, etc. I'm not even going to worry about any other words because I've already narrowed pretty far. And then I'll continue and then apply. And I go. I went just to give you a sense of how this works, I went from 62 cases to 7. So I take a look and see how denial is talked about in these 7 cases. And again, denial is found in the head notes, not in the full text of the case. But that's okay. So you want to know about that because you want to think about what terminology you're using when you use your search when you do your search within results search. Okay, so that is number 1 way to use one good case. Just click on the head notes, whichever one sounds the most relevant. Change your jurisdiction. See what you find. Maybe search within results, maybe not. You don't have to. By the way, one of your handouts, Techniques for Finding Cases, pretty much sets forth what I'm describing to you. So we are currently under Westlaw, and we're talking about A, where we've done a keyword search. Well, basically, we found a case. One way is a keyword search, and now we are using head notes from a resulting case. And pretty much steps 1 through 4 is what I just did. Any questions? Okay, so another technique for using this system, I'm going to go back to Westlaw and so here I did a search in Westlaw for liability, in quotes, health maintenance organization. I've been lazy about doing HMO. Better search is health maintenance organization, in quotes. Just a regular keyword search. I've kept the jurisdiction all state and federal because I want as wide a result as possible because I want to now narrow it. And the way I want to narrow it is using the filters. And the filter I want to use is the key number filter. Now, yes, we can narrow by jurisdiction. We've talked about that. Actually, I promised you earlier when we were talking about reported versus unreported cases. Here's the filter on Westlaw for reported status. But what we're talking about now is finding cases on a topic and using the key number filter. So I'm just going to expand that, and what Westlaw brings up are all of the topics that are in the cases that it found. So however many cases we found in the search, and there's probably a whole lot, these are all the topics in those cases. So what I'll do now is just scroll through, and even though it seems like a lot, it's not going to take that long. I know that assignments isn't of interest. I might already have a sense of the topics I'm interested in from my earlier research, or if not, I just scroll through a little bit more slowly. But we already know, for instance, that we are interested in health. So I can either search the whole health topic, but that's really kind of broad, right? So what I can do is I can click on the plus sign. And that just breaks it down for me. So here are the different subtopics. So I can take a look at the subtopic and I think, oh, look, yeah, malpractice. That's what we're interested in. And if I want to break that down further, I click on the plus sign. And then I could see, again, there's always the in general, particular proceedings, duties and liabilities of non-patients. I could person's liable. Maybe I just want to do the whole person's liable. Or if I want, I'm deciding I don't really know what the difference is between these and I'm not really sure. So you know what? I'm going to do the whole subtopic just by clicking on it. And there you can see it appears on the right. So now I don't have to worry about which, if I start to get confused about what all the subtopics are covering, I probably will just go with the topic overall. But here's the cool thing about this system. Unlike the first method, or this method, the first method we looked at, we just click on one single key number. So that's the under insurance. Okay, that was good. Now what I can continue to do, so that was health, but I'm also kind of interested in the insurance aspect of this. So I just keep on going to the insurance topic, and same thing, I break it down with the plus sign, take a look and see, ooh, what law governs? That looks to be about the best ones, because we now understand that that's what preemption comes under. Click on the plus sign, choice of law, preemption. Oh, maybe I really want to narrow in preemption. And then application of state or federal law. So there's all of these. particular laws or activities. Again, I'm getting to the point where I'm not quite sure what all this is, so I'm going to keep with that topic, that subtopic or sub-subtopic. And then when I think I'm done, I mean, I could keep on going and look for other topics. And when I've decided, okay, I think I found everything that's worth finding, continue. And then with Westlaw, you always have to remember to apply. So within my keyword search, I'm narrowing to cases that have my particular tags of interest. Apply. And again, this is basically what I'm describing in Westlaw B. So use the key number filter and then just choose your topic and key numbers. And so you can see I've narrowed it. I could search within these results if I want. See, search within results. I could narrow by jurisdiction if I decide, okay, now it's time I really want to look and see what's going on in New York. Any questions? So that is advanced search number 2. That's why we're in advanced legal research. Advanced search number 3, part C, is the advanced cases search, the literal advanced cases search. So on Westlaw, we've talked about using the advanced search, and you need to narrow by content type before, really to use the advanced search effectively. So of course we're talking about cases. When we talked about the advanced search last time, we were talking about secondary sources. So then I clicked on secondary, now I'm clicking on cases, and then I'm going to the advanced search. I'm being bibliographically aware and noticing that Westlaw, for some reason, is remembering New York State and Federal. That's okay for now. As long as you're aware, I can switch it out if I want. So here's the advanced cases template. And the way I can use this for an advanced search is using the different parts of the case. Remember, I pointed those out in the case that was a poem. Let's take a look at a more serious example here. This is Westlaw's example of the different parts of the case. So there's the party name and the docket number. And again, here's the synopsis, the summary of the case, what the case is about. Here are the head notes. And what Westlaw calls the head notes is they also call the digest. So the digest actually searches the text of the head notes as well as all this hierarchy. So I am going to use that knowledge where I can find there's my template, my advanced template. So I clicked on advanced. And fields, the different parts of the case are called fields. I can search just the synopsis. I can search just the digest. But I kind of like to search them both because they both basically tell me what the case is about. But they really focus in. There's no extra language here. So I might, in my synopsis and digest search, I might try a keyword search. So, and here I will be a little more sophisticated. Or actually, what I'm going to do to be really sophisticated is I can combine fields. So I might want, all over the document, in the opinion everywhere, I might want my standard terms liability within the same paragraph as, and again, this is on your handout. Yeah. Oh, I have within the same paragraph as HMO there. I'm going to follow my own advice and spell this out properly. Maintenance, organization, close the quote because I want that as a phrase. So that's going to search the entire case, the opinion and everything. And then I'm going to tell Westlaw, okay, but I want to be really sophisticated here. And I also want you to find focus in within the synopsis and digest, any form of the word deny, so DEN exclamation, within the same paragraph as cover or coverage, covering. Or benefit or care. So denial of coverage or denial of benefit or denial of care. And again, I'm limited by jurisdiction here. We'll see what happens. Okay, so not too many because I'm limited just to New York Federal, but that's okay. You might want to expand that out to see what other cases out there that might be persuasive. I usually like to start broader and work my way narrower because sometimes the broader will help inform my strategy as I narrow in to my jurisdiction. Any questions about the advanced cases search? So these are 3 different advanced search techniques for cases. If you go on Google Scholar and you find a great case and you make sure it's good law, you still want to make sure, still good law, you still want to make sure there are not other cases out there. You might be able to do that on Google Scholar. You might want to come on Westlaw or Lexis. If that doesn't work for you, these are not strategies you're going to want to use every single time. These take time, take a little bit of thought. These are strategies when the easy way doesn't work, isn't giving you relevant results. Okay, a couple of other advanced search techniques I want to show you within cases. It used to be, assuming I can get back there, come on Westlaw. So it used to be finding a case that defines a particular word. So a judge says, this is what malpractice means in New York State, or this is what liability or means in New York State. It used to be really hard to do a keyword search to find that. It's easier now. You can actually discern, definition, malpractice, and the search, the plain language search is pretty good. But if you're having trouble, on Westlaw, there is this feature, again, in our advanced cases search called words and phrases. And what words and phrases does is it narrows in on cases in which a judge defines a term. So it basically narrows the world of cases you're searching into cases in which a judge defines a term, and then you can put in your term. So I gave you the example of malpractice. So how do judges define malpractice? Now I'm back in all jurisdictions, but that's okay. Again, you just have to be aware. Actually, I still have the rest of my search terms in there, so I'm going to get rid of those. So I just want to search how judges define malpractice. So that's the words and phrases field in the advanced search. Another kind of cool field in the advanced search, if you're appearing before a particular judge, you can see what that judge had to say about a particular issue. That's just going to be a strategy you may want to employ as a litigator, if you are a litigator, to see what a judge has to say. And you can do that here by the written by field. So you put in your judge's name. Obviously, you're probably going to narrow to a jurisdiction. So if I wanted to see what Judge Alito had to say, again, I'm not going to narrow by jurisdiction, just out of laziness or for time efficiency. But this will give me whatever court Judge Alito is in. So he was in a circuit court, and of course now he's in the Supreme Court. So it would give me all those cases in which Judge Alito wrote an opinion. Any questions? Okay, so now we're going to do part of the workshop. I have a hunch we will not finish it. We're going to do part of the workshop, we're going to stop and then talk about Lexis, Bloomberg, and some other services, but we're going to do the Westlaw part first. Actually, I'm just going to pause this. West's tagging system, the topics and headnotes that we've just been looking at for a while, is probably the most sophisticated. It's been around the longest for a couple of 100 years, give or take. Well, 100 years anyway. Lexis and really Bloomberg are kind of playing catch up with it. I think they both started with the idea of everybody just does keyword searching. We don't need to bother with this. And then they realized, well, my keyword searching doesn't always work so well. So what Lexis has done, since they've been around quite a bit, actually Lexis started before Westlaw, but they've started catching up with this quite a bit more recently. So again, the idea of the one good case, I'm going to pull up our Aetna case. And it's kind of like Coke and Pepsi. The concept is the same. Cola is cola, but their formulas are different, so some people think they taste different. So here we have Lexis head notes. So it's the same concept of tagging. They just look a little bit different. Instead of, that whole hierarchy, it's a little simpler. So in looking, and the head notes are totally different. So don't think if you look at Westlaw, you're going to find the same head note on Lexis. You will not. So you can see head notes 1 has to do with jurisdiction and subject matter and federal government. I'm scrolling down the head notes. So down here to head note 4, we get to ERISA federal presumption. So that's of more interest to us. And actually, head note 3, head note 4, ERISA civil litigation. So all of these different aspects that might be of interest to us. And essentially, as I said, it's the same concept of tagging. And it works pretty much the same way, where we will want to click on whatever is of interest. So federal preemption. So if I just click on the arrow and I go to Get Documents, eventually Lexis will pull up other cases that have that same head note. And again, I can limit by jurisdiction. I can search within results. All of the same concepts apply. One thing Lexis has that Westlaw doesn't, that is sometimes useful, and it depends on your issue and case. And we actually saw this feature in secondary sources as well on Lexis, in the About This Document. So I'm back here at the Aetna case. In the About This Document feature, tab, whatever you want to call it, on the right, I see something called topic summaries. What Lexis is providing for us is a summary on what they guess is the topic of interest in this particular case. And if I view those reports, punitive damages isn't really interesting, but suit to recover plan benefits might be. And what Lexis does for us is gives us some leading cases. Interestingly, it doesn't give us the Aetna case, but it gives us elements. It gives us reference to code section. So remember, 1132 is of interest as well, and some secondary sources that might help explain things. So again, that is hit or miss, but worth checking out if you do find a case of interest. Lexis also has an advanced search. What's nice about the advanced search is it's a little easier to get to. You can go to the home page and then just go to advanced search. You don't have to worry about remembering of choosing your content type the way you have to on Westlaw. And then on the bottom, you can choose whatever content type of interest. You do actually need to choose content type because different types of documents are going to have different fields. So you're not going to find a headnotes field in a secondary source because secondary sources don't have headnotes. Only cases have headnotes. So here you can scroll down and you can see the different fields that you can search by. Now Lexis doesn't have the Synopsis Digest field that I'm suggesting you use in Westlaw. But you can search just in the headnotes. Sometimes what I will try is also what Lexis has is something called core terms, which is basically pulling out the key terminology in a case. So that can be useful if you want to try to narrow. And what I will show you is, so these are segment examples. On Lexis, they call the parts of the case segments. On Westlaw, they call them fields. So here you can see what the different segments are. So here's the core term segments. Here's the summary, overview, the headnotes we already know about. So if you're wondering what these different fields or segments are, you can click over here, and that will give you the explanation. And just as we did before, once you run a search on Lexis, you have search within results. The same is true if you use the headnotes. So all of those filters still apply. Let's see. So if we were to click on a headnote, just as we did before, again, it sometimes can be a little confusing. You click on it and you need to get documents. Don't really know why they do that, but so it is. And as I said, you've got your filters, including search within results. So we could search the same terminology we did before, obviously, whatever terms you think are relevant. So searching for the headnote and then terminology within our results. Questions? Yeah. I don't mind in the slightest. So again, you do your keyword search, you find that one good case, or you pull that one good case up from wherever you found it elsewhere on Lexis. You scroll down, you take a look at the headnotes, you figure out which headnotes you think look, or headnote you think looks interesting. So if we go here to federal preemption, I see the link, and I click on that headnote wherever, and then get documents. And just to finish up with the advanced search, again, on the home page, advanced search, and then scroll down and choose advanced search for whatever type of. So probably what I use the Lexis advanced search for is the written by. Again, if you have a particular judge, you want to see what Judge K in New York said about a particular issue. She's, I think, already retired, but if you've got an existing judge and you want to see what they talk about, you can do that on Lexis just as you have on Westlaw. So you'll see different choices on Lexis, written by, opinion by. Stick with the written by, that's the safest. The difference is written by would be any kind of opinion, dissenting, concurring. Opinion by would just be the opinion of the case, the deciding opinion. But as I said, if you stick with written by, that's safest. Now I've zoomed through Lexis, not because it's not important, but because we've already talked about the concepts. But if there's anything that's confusing, otherwise I will move to Bloomberg. Now Bloomberg has, come on Bloomberg, stop being annoying. There we go. So Bloomberg has a different approach, which is kind of interesting. Most of you, from what I've been hearing and reading, aren't huge fans of Bloomberg, and I understand that. Bloomberg has tried to duplicate the headnotes, but they haven't done the greatest of jobs, or they haven't been very there we go. So you can see sometimes in some cases you'll see this show headnotes, little tab in the middle here. A lot of times you won't. So they haven't been very thorough about adding headnotes. But they've developed a different system which they really are promoting, and that's called points of law. So if you've already found a case, again with our one good case strategy here on Bloomberg, on the right, if they have it for the case, you'll see points of law. And what Bloomberg will do is it will highlight different aspects of the opinion. And you can scroll through here. I clicked on points of law, and now I'm just clicking on next. And I can decide, okay, which point of law am I interested in? So civil action brought by the state. If that's the one I'm interested on, I click on it. And what it does is it gives me other cases that discuss that particular point of law. So it's kind of like headnotes in that you click on it and you get more cases that talk about the same area of law, but you don't have that whole tagging topic headnote system. You just click right on the actual part of the opinion. You can also access this point of law feature on Bloomberg on their homepage, which is also kind of cool, I think, right here under points of law. And you can do a keyword search within that whole points of law feature. So if I try ERISA/P preempt, what Bloomberg gives me are the different points of law that have my key terms, and I can go through and say, okay, is that point of law describe what I'm interested in? And if it does, it will give me 12 opinions that talk about that point of law. So again, you can get to points of law from one good case, or you can just do a keyword search. So a little bit different, kind of interesting. And one aspect of Bloomberg that we will investigate in more depth again after spring break is Bloomberg, because it's business oriented, tends to organize itself more along business lines. And what I mean by that, so if we're interested in cases and we go to court opinions, Bloomberg pops up this search box, and if I scroll down, it gives me the opportunity to narrow by industries. Is this useful for the example we're using in our class? No. Could this be useful in other, if you are representing, say, a business? Yeah, possibly. So you can take a look at the list of different industries that you could narrow by. Bloomberg also lets you narrow by topic. Lexis and Westlaw also have topical arrangements as well. So I will show you that so you can see that concept. So on Westlaw, we go back to the home page. You have practice areas, so you could narrow your search that way. That's good as long as you're confident that your issue falls within a particular practice area. Our particular issue for our client, it's insurance, it's health. I'm not really sure how that would be classified, so I would be a little reluctant to use it. But if you know you have a copyright question or whatever other question, narrowing by practice area, any of these three services might be a good strategy. Okay. So the last database I'm going to show you, I've talked about but I haven't showed you yet, and that's Fastcase. You have a handout from Fastcase. The reason you might be interested in Fastcase, if you wind up working somewhere that can't afford Lexis or Westlaw, or you decide you want to hang out your own shingle, and Lexis and Westlaw, as we've talked about a lot, is really expensive. Fastcase is a lot more affordable. If you decide, as law students, you can join the New York Bar Association, I believe, for free. Once you graduate, no longer. But if you join the New York Bar Association, which is a great way to get all sorts of benefits for CLE, and y'all know what CLE is? Okay, good. CLE and just networking and other contact and educational opportunities. As a member of the New York State Bar Association, you would have access to a portion of Fastcase as part of your membership. So you would essentially have this system already paid for. If you just subscribe to Fastcase, like Bloomberg, it's a flat fee. Once you subscribe, your monthly subscription fee, you can search as much as you want. You don't have to worry about all these issues with Lexis, like you do with Lexis and Westlaw, in terms of how much you search and what you click on and inside and outside of your contract. So here's what the homepage of Fastcase looks like. when I investigate a new database, I do a couple of things. Just run a search and see what it looks like. I also see if I can find their advanced search. So I might just click on different options. So if I clicked on options here, I would find the advanced search. I'll be honest with you, I don't find Fastcase especially intuitive, but if it's all I had available, it would certainly be better than nothing. So you can see what Fastcase looks like. I'm going to run one of our favorite searches, liability, HMO, denial of care. And yes, I'm being lazy, back to being lazy again and typing HMO. And they've got this cute little character. So Fastcase, as you can see, looks a whole lot different than anything we've seen. It's a very busy screen. So there's lots going on here. So here in the middle, we have the case results. I haven't narrowed by jurisdiction yet. I could have done a pre-search filter, although I don't find that particularly easy on Fastcase. I could also do a post-search, which I do find a little bit easier over here under jurisdiction. I can narrow. They have something called authority level, so I could narrow by different. Authority level is really more different. Well, you can see what it is. Federal district, federal bankruptcy, so it's different courts. I can narrow by document type, so I haven't done so yet. We could narrow by cases. This is a word cloud. I'm guessing most of you have seen word clouds in other contexts where it figures out, the words that are used the most and they're the biggest, and then it reduces. The amazing thing I find about Fastcase is every time I do a search, different words show up in the word cloud. Haven't figured that one out yet. I have to ask our Fastcase rep about that someday. We have here the interactive timeline. This is probably the most innovative feature of Fastcase. These blobs are actually cases, and the bigger the blob, the more the case has been cited to. You can narrow in on different cases and different points of time here. And then here on the right, the most interesting aspect, this is the other most innovative aspect of Fastcase, is this feature called Foresight. Fastcase is basically guessing, through what they call artificial intelligence, cases that don't contain our keywords, but might still be of interest. This is a whole computer algorithm. Sometimes it can be extraordinarily useful, sometimes not. So that is a quick introduction to Fastcase. I wanted to know about that again because Lexis and Westlaw aren't the end-all, or Bloomberg aren't the end-all and be-all, and it's a good thing to know about, again, if you find yourself in a situation where you don't have easy access to Fastcase. I also gave you a handout called Cara. Cara is another new service trying to take advantage of artificial intelligence. Cara is sort of research, sort of drafting. I'm not going to go into any detail other than just highlight you to be aware of it. Basically, you can upload an already existing brief or document to Cara, and Cara will, again, using what it calls artificial intelligence, try to figure out what other cases are relevant based on what you've uploaded. There actually is also a search function. As law students, you can use it for free. Once you're out of law school, you would have to pay for it. So if you're interested and you're interested in the new technology, Cara might be fun to play with. So again, we're not going to go into any more depth about that, but it's worth knowing about, and maybe if you're lucky, wherever you wind up working either for the summer or after you graduate, might have access and give you more opportunity to play with it. Again, you can play with it now as law students if you set up an account for free. Any questions? Okay, so we have a few more minutes to work on the workshop. And whatever you don't